We're here at the Morningstar Individual Investor Conference 2018, and I'm talking with Shane Ellis from Shane Ellis Legal Group, and he's discussing the transfer balance caps. Now, Shane, what's actually changed in this regard?
Basically, with the changes in the law, pensions are now capped at $1.6 million, and it largely means that non-concessional contributions in relation to your self-managed super fund or superannuation interests can only be made non-concessionally up to the level of that cap. Mm-hmm. From there, what we've got that we'll be looking at is also in relation to the type of pension that you're dealing with, and as to whether that's called reversionary or non-reversionary, and what the consequences are in those circumstances when the member dies and he wants his pension to be dealt with within the fund. And then we're going to have a look at the quality of the documentation and how that impacts upon things.
Now, these changes have come into place now, or when exactly has the change occurred?
This is part of the laws that came in November of 2016 and largely commenced from 1st of July 2017. So, the caps have been there and need to be complied with now. People really need to be mindful of the way that they deal with their pension interests and also their superannuation interests upon the death of their spouse.
Sure.
And by taking a close look at that, you can actually keep more in the fund. By not playing with the game rules and that, you might actually have money ejected from a fund. And as I just alluded to a moment ago, once it goes out, it's really hard to get back in.
Sure. And you're also referring to some really recent case law that's tested some of this in the courts in Queensland, I believe.
Yeah. It's always been the case, regardless of whether we're talking before the new laws or now with the current laws, that the quality of the documentation is imperative. And this particular case is called Nurman's case, and it was only handed down 2 months ago by the Supreme Court in Queensland. And it addresses a number of issues in relation to pension documents and the quality of the documents and how that impacted upon the facts in the case. So, as I said, really recent one, really on point in relation to what we're talking about. So, yeah, and it makes it just a little bit more interesting than just dealing with the statute and how it applies.
Sure. So, and is this something that applies more so to existing trustees versus people who are prospective people who are about to set up an SMSF?
The quality of the documentation is imperative across the board. A lot of people on that are out there and they're shopping at times. They buy very cheap documentation. When I've spoken to large groups, especially at some of the Morningstar conferences in the past, where we can have 300 and 400 people in the audience, I can ask the audience, how many people here have actually read their trust deed, and you get a spattering throughout the audience that actually put up their hands. So a lot of people don't think that it's important, but from the start, the quality of your trust deed is imperative, because the trust deed is the book of rules. It's critical, all right? And again, this case talks about the super fund deed and the court going back to it to have a look at what was taking place.
Any advice in this video is general advice prepared by Morningstar without reference to your financial objectives, situation or needs. You should consider the advice in light of these matters and any relevant product disclosure statement before making any decision to invest.